Good morning and welcome. My name is Ben Duggan and I am presenting the seminar today entitled The End of JobKeeper, What Next for Employers. Normally for seminars of this nature, I'm presenting to a room full of people, and the safety message that's provided is reflected in the fact that they are present and reference might be made to the available toilets and facilities. Under the new COVID environment though, my task is to ask everybody to mute their devices, and also in terms of questions, if you can place these in the chat box, and my intention is to address these at the end of my talk. In terms of the discussion today, the title of the presentation was set before we knew of the extension of the JobKeeper scheme. In terms of my today, it's to focus on the recent developments. That is the proposed extension of the JobKeeper scheme, which has been dubbed JobKeeper 2, as well as the extension of the flexibilities that were introduced in the Fair Work Act as part of the original JobKeeper scheme from September. By way of introductory remarks, the JobKeeper scheme, of course, was introduced in March, the commencement of the COVID-19 pandemic. Some nearly 1 million organisations have benefited from the scheme, and more than 3.5 million employees have been eligible for the scheme and have benefited from the $1,500 fortnightly JobKeeper payment. JobKeeper, as we know, was originally expected to operate for a period of 6 months until the end of this month. Yes, it is September today. In mid-July, the federal government announced that it would be extending JobKeeper for a further period of 6 months until the end of March next year. The situation in Victoria has obviously deteriorated since that time, which has prompted the federal government to review the scheme, in particular to ease eligibility requirements under the extended JobKeeper scheme from the end of this month. So as I've said, my talk today will focus on the new extended JobKeeper scheme, which as has been mentioned, has been dubbed JobKeeper 2. The second iteration of the Fair Work amendments, designed to provide flexibility for JobKeeper employers, will also be extended. The bill for JobKeeper 2 was placed before Federal Parliament last Wednesday. The JobKeeper 2 bill has passed the House of Representatives last week and is expected to pass the Senate this week. JobKeeper 2 extends the wage subsidy for a further period of 6 months. This 6-month period is divided into 2 extension periods. The first of these extension periods running from the 28th of September 2020, that is the end of the original JobKeeper period, until the 3rd of January 2021. And the second extension period then, running from the 4th of January 2021 until the 28th of March 2021. The government has indicated its intention to continue to support businesses if there is not an improvement in the health situation, particularly in Victoria, so it may well be expected an extension of the scheme beyond that time. An employer will need to satisfy new eligibility criteria to be eligible for one or both of the extension periods. An eligible employee will be paid a tiered amount based upon their hours of work. In Australia, there will be three groups of employers for the purposes of JobKeeper 2. The first group of employers is the non-JobKeeper employers. These are employers who did not qualify for the original JobKeeper scheme and will not qualify under the new JobKeeper 2 scheme. Employers in this category will obviously not receive the wage subsidy under JobKeeper 2. Employers in this category will also not be able to utilise the Fair Work JobKeeper flexibilities. The second category is the JobKeeper 2 employers. These employers will qualify under the new JobKeeper 2 criteria. The criteria will need to be satisfied, as was said, in relation to both extension periods. The criteria for the first extension period, being the period from the 28th of September 2020 to 3 January 2021, is a fall in GST turnover of 30% for a business with turnover of $1 billion or less, or a fall in GST turnover of 15% for a registered charity other than universities or schools for the last quarter. That is the quarter from July to September 2020, relative to a comparable period, which will be the corresponding quarter in 2019. So in effect, there's a comparison between the last quarter of 2020 to the corresponding quarter in 2019, and there needs to be a significant reduction in GST turnover. For a business, it's going to be 30%. There's a different criteria that applies to businesses with a turnover of greater than $1 billion. And if an employer satisfies that criteria, they will then be a JobKeeper 2 employer for the first extension period. A further assessment for eligibility for an employer will also occur for the purpose of the second extension period, which will occur early next year. The criteria for the second extension period, being the period from 4 January 2021 to 28 March 2021, will be the same as the first extension period. That is, for a business that has a turnover of less than $1 billion, a fall in GST turnover of 30%. By way of comparison between the quarter from October to December 2020 to the comparable quarter in 2019. So again, there's going to need to be a 30% reduction in GST turnover, or alternatively for charities, 15% in the corresponding quarter from last year. Turning now to employees who are going to be eligible under the scheme, they will be entitled to receive the wage subsidy from their JobKeeper 2 employer under either or both of the first extension period or the second extended period, depending on their employer's eligibility under the scheme. Eligible employers will be able to utilise the Fair Work JobKeeper flexibilities, and they will receive the wage subsidy under either or both of the first extension period or the second extension period, subject to eligibility. So the possibility exists that some JobKeeper 2 employers will be eligible in either one or both of those extension periods. The third category of employers is legacy employers. Now, this is the term that the bill uses to describe those employers who qualify for the original JobKeeper scheme but do not qualify for JobKeeper 2. A legacy employer must be able to demonstrate that their turnover has decreased by 10% in relevant quarters compared to last year in order to be treated as a legacy employer. And for these particular employers, the legacy employers, they will not receive the wage subsidy under JobKeeper 2. However, in recognition of the impact on their business of COVID-19, legacy employers will still be able to use, on a modified basis, the Fair Work JobKeeper flexibilities that were introduced into the Fair Work Act at the commencement of JobKeeper. Turning now to eligible employees, an employee is eligible where they are currently employed by a JobKeeper employer, including in circumstances where they have been stood down or rehired. They must be employed as a full-time, part-time or fixed-term employee as at 1 July 2020 to be eligible under JobKeeper 2, or a long-term casual employee, that is somebody employed on a regular and systematic basis for at least 12 months, as at 1 July 2020, and interestingly, not a permanent employee of another employer. And this picks up a concern that the government had about some employees double dipping. They must be 18 years and older as at 1 July 2020. And this picks up, obviously, there were some employees who were thought to be eligible at the commencement of JobKeeper who turned out to be students. And the encouragement there is obviously to pay it to those over the age of 18 who have left school. Other criteria related to the receipt of other social security payments, which acts as a disentitlement to an employee who is employed by a JobKeeper 2 employer. In terms of the JobKeeper payment, the current payment, as we would all know, is that eligible employees are paid a minimum of $1,500 gross per fortnight. The JobKeeper 2 scheme has been tailored to introduce a scheme which is different during the 2 extension periods, as well as a tiered scheme for employees. In relation to the first extension period, there will be a Tier 1 rate of $1,200 per fortnight, and there will be a Tier 2 rate of $750 per fortnight. We then move into the second extension period, and for the second extension period, the Tier 1 rate will drop down to $1,000 per fortnight, and the Tier 2 rate will drop down to $650 per fortnight. In terms of those 2 tiers, a Tier 1 is an eligible employee who was working for 20 hours or more a week in the 4 weeks either before 1 March or 1 July of this year. And a Tier 2 is other eligible employees. The intention of Tier 1 is largely to capture regular part-time and full-time employees, and Tier 2 is largely designed to capture casual employees and irregular part-time employees. Turning now to the continuation of the Fair Work flexibility provisions, which were introduced in conjunction with the original JobKeeper Payment Subsidy Scheme, the JobKeeper laws introduced at that time included amendments to introduce temporary measures to the Fair Work Act to assist a JobKeeper employer to manage their workforce in response to the COVID-19 pandemic. A JobKeeper employer under those temporary measures was provided with greater flexibility to make changes to 5 key terms and conditions of employment for eligible employees who continued to work in their business. All current workplace arrangements that might prevent the introduction of these greater flexibilities utilised under these new provisions was overridden by the JobKeeper laws. JobKeeper employers were initially given the option to use these flexibilities for an initial period of 6 months. In terms of those flexibilities, I mentioned that they dealt with 5 key terms. Those flexibilities dealt with the ability to change days of work, the ability to change times of work, the ability to change duties of work, the ability to change location of work, and also hours of work. In terms of the way in which they operated, effectively they were designed for employers to be able to make changes in a quicker and more efficient way without reference to existing industrial arrangements, which were considered to be too inflexible to deal with the speed in which changes needed to be made due to the coronavirus situation. The flexibilities introduced also enabled employers to require more easily employees to take leave, in particular annual leave. Currently, under the JobKeeper flexibilities, an employer can reach an agreement with an eligible employee to work different days of work, to work different times of work, and to take annual leave at half pay. All of these are designed to provide greater flexibility in the workforce, particularly in Victoria, which has been hard hit by the coronavirus situation, and where flexibilities around these matters, in particular to enhance the ability of social distance within the workplace, are critical to businesses in that state. Separately, a request may be made by a JobKeeper employer to an employee to take annual leave, and that request must not be unreasonably refused. Now, there is a decision which is referred to in the PowerPoint presentation, which is a matter that went to the Commission, where an employer had requested that an employee take leave, and the employee challenged that request. And the Commission was quite strong in finding that it was reasonable for a business that was suffering because of the coronavirus situation to request that their staff member take annual leave during this period as a way of dealing with the lack of work. In terms of that particular decision, a lot of employers have taken advantage of that decision, the principles within that decision, to require their employees to take annual leave during this difficult period where there's been a reduction in workflow due to the coronavirus situation. In terms of what's new under the new arrangements, so the new arrangements under the Fair Work JobKeeper Mark II legislation, there will be restrictions for legacy employers in relation to these agreements that they can reach with eligible employees. And in respect of those agreements, they cannot result in the eligible employee working less than 2 consecutive hours in a day. So that's a new requirement that will be introduced as we move from the JobKeeper legislation Mark I to Mark II. Interestingly enough, the flexibilities in relation to annual leave that have just been described will not be continued beyond the 28th September 2020, at which time they will be repealed. So for those businesses that are looking at utilising the annual leave benefits flexibilities that are available under the current scheme, they need to be used in the very near future, because they won't be available beyond the 28th of September 2020. The other flexibility that currently exists under the scheme is the ability to provide what's been called JobKeeper Directions. These JobKeeper Directions can be a direction for a stand down, they can be to change duties or to change location of work or hours of work. In terms of a JobKeeper stand down direction, it's important to remember that these may only be provided where an employee cannot be usefully employed for their normal days and or hours because of requirements introduced by governments to control the spread of coronavirus. So they can't be utilised simply because there's a lack of work. There needs to be a connection between that lack of work and the coronavirus situation. A JobKeeper employer is able to provide a written stand-down direction to an eligible employee of their workforce, which currently has a notice of period of 3 days. In terms of a stand-down, that's similar to the pre-existing requirements for a stand-down under the Fair Work Act, in that there needs to be a stoppage of work that's effectively caused outside of the employer's control, which then justifies a stand down, the effect of which is there's no obligation to continue to make payments to an employee because of that stand down. The other conditions for a JobKeeper stand down direction under the flexibilities that exist under Fair Work include the following: that the JobKeeper employer must consult with the employee before giving the direction, that there are some safeguards in place, in particular the JobKeeper employer payment obligations which must be complied with, which involve the satisfaction of the wage condition, and they will continue to apply, and a direction must not be unreasonable in all of the circumstances. The safeguards that a JobKeeper employer must currently comply with include, that is, when providing a written stand-down direction, include the following. The JobKeeper employer is required at the moment to comply with the wage condition obligation, which is to make the minimum payment of wages of $1,500 to an eligible employee. The JobKeeper employer is required by the minimum payment guarantee not to decrease the base rate of pay worked on an hourly basis under the stand-down direction. And the JobKeeper employer is required by the base hourly rate of pay obligation not to decrease the hourly rate of pay under the stand-down direction. In terms of and that's the current scheme, we then move to the new scheme, which is going to be introduced from the end of the month. In terms of the current requirement, there is a current requirement under the scheme in relation to the issue of reasonableness. The way in which that reasonableness requirement works is that a JobKeeper direction which is given by an employer to an eligible employee does not apply to that employee if the direction is unreasonable in all of the circumstances. And at the moment, in that particular provision of the Act, there is a note saying that a direction may be unreasonable depending on the impact on the direction on any caring responsibilities that the eligible employee may have. There will be a new requirement under the bill, and that adds an additional note to the one that I've just read out, which provides that employer directions which reduce hours for a category of employees may be unreasonable if they have an unfair effect on some of those employees compared to other employees who are subject to those directions. And this note really picks up some of the decisions we've seen from the Fair Work Commission where they've been dealing with JobKeeper disputes. What some employers have done is if you take a cohort of 5 people, say 5 staff members, all doing the same work, what some employers have done is they might have stood down, say, one of those five, or made a decision which has an impact on one of those five. The Fair Work Commission has looked pretty closely at that situations in this consideration of the reasonable test. That is whether the direction was reasonable. And it has come to the conclusion on a number of occasions that that was unfair for that one particular employee, and that a more balanced across the board approach should have been taken. That is that each five of the relevant cohort of employees should have been impacted in the same way. So, for instance, rather than standing down one employee, that what the Commissioner suggested should have happened under this reasonable test is that each employee should have had their hours reduced by 10%. And in that way, each employee has been equally impacted. And this note really picks up on those decisions that we've seen coming out of the Fair Work Commission in relation to this reasonable test, and actually specifically codifies the requirement as a note in the reasonable test in relation to these directions that employers can still give under the new JobKeeper Mark II legislation. In addition to that, in relation to all JobKeeper directions, if you are a legacy employer, you will need to provide a greater notice period of 7 days rather than 3, and you'll also have some expanded consultation obligations with an eligible employee, which include consultation with their union representative. In terms of a stand-down direction, so a direction that's given to stand down an employee or a group of employees, for legacy employers, it must be that a minimum of 60% of the employee's ordinary hours as they were at 1 March 2020. So to do the stand down, they must do it on the basis that the employee is working a minimum of 60% of their hours under that stand down. So in effect, it can't be a complete stand down, and the direction cannot result in the employee working less than 2 consecutive hours in a day. And it's obviously picking up a theme that goes throughout these changes, which is obviously a concern that's been raised by stakeholders with the government. But you can see from that what the government is saying is that for those legacy employers which have been impacted, but not to the same extent as the JobKeeper 2 employers, that they're not able to use the general stand down. There's a safety net there which has been determined to be at a minimum of 60% of employees' ordinary hours. There's no change though for JobKeeper 2 employers in relation to this requirement, recognising the more significant impact, particularly in the state of Victoria, of these employers who continue to be poorly impacted by the coronavirus situation. In terms of JobKeeper 2 disputes, the Fair Work Commission currently has the power to deal with disputes relating to the current JobKeeper legislation, and a dispute may be referred to the Commission by either an employer, an eligible employee or their representative. And the Commission can deal with these disputes, including by way of making recommendations to the parties or by way of arbitration. When exercising its powers, the Commission is required to take into account fairness between the parties, which provides it with a broad discretion to consider a range of matters when dealing with disputes. The type of matters that the Commission may consider include the financial position of the employer, the personal circumstances of the employee, and the impact of government restrictions on the business of the employer. And the Commission has the power under this legislation to make any orders that it considers appropriate, including an order they deem desirable to give effect to a JobKeeper direction or an order setting aside a JobKeeper direction. The powers to deal with JobKeeper disputes were intended to continue until the 28th of September 2020, when they were first introduced. They will now be extended, consistent with the extension of the JobKeeper wage subsidy scheme. And the Commission will continue, is intended to have powers until the end of JobKeeper 2. In terms of one other interesting aspect is that what can now happen is that the ATO, who of course are gathering significant information in relation to JobKeeper employers and their eligible employees, now has the right to share information directly with the Fair Work Commission for a JobKeeper purpose. So in relation to the disputes, it is possible for the sharing of information between these agencies to occur, such that the Fair Work Commission has relevant information about a JobKeeper employer that might be in dispute with one of their eligible employees. In addition to that, as has been discussed, one of the areas that the Commission has focused very much on is the question of reasonableness between different employers, between different eligible employees in terms of decisions that employers have made that have an impact on them. And that's certainly been a fertile area where employers have had difficulties in terms of justifying their decisions, as described earlier. Turning now to flexibility for non-JobKeeper employers. For non-JobKeeper employers during this initial period, and indeed under the new JobKeeper scheme Mark II, they're of course left with having to navigate current contracts of employment as well as any current industrial instruments such as modern awards. Trying to achieve, as we know, changes to an employee's days, time of work, duties and location of work is much more difficult under contracts of employment as well as modern awards than it obviously is under the JobKeeper legislative changes made to the Fair Work Act, obviously designed to make it more flexible to achieve those changes. The other area of annual leave, which has been an area where employers in this difficult time have asked their employees to take leave, is again an area that is less flexible under modern awards. The general requirement under a modern award will require a greater period of notice to be provided to the employee when the employer makes a decision to unilaterally require their employee to take annual leave. In addition to that, there is also generally a requirement that they have a greater bank of annual leave at the end of that direction to take such annual leave. So it's much more flexible, obviously, under a modern award than it is under the Fair Work changes to accommodate JobKeeper employers that we've discussed today. The other ways in which non-JobKeeper employers may get to a situation where they can't agree with their employees and they need to make changes, it may be necessary to make unilateral changes. Those directions to take leave, as I've said, are less flexible under the modern award. The other situations you might look at doing are reducing an employee's hours of work. Again, that's very difficult to achieve in circumstances where you're looking at doing that unilaterally, and that triggers a potential argument from the employee's perspective that they've been made redundant if, for instance, you're moving them from a full-time role to a part-time role without that ability to do so under a modern award. The other options you've got, and a lot of employers are doing this who have been impacted but not to the extent of being an eligible JobKeeper employer, is to look at restructuring their operations. And in terms of restructuring their operations, there's obviously a lot of redundancies that have occurred in the last 6 months, notwithstanding the wage subsidy scheme, which has existed for the benefit of those employers who are eligible for the JobKeeper scheme. JobKeeper, of course, doesn't prevent you from terminating somebody on the basis of redundancy. But again, it's something that the Fair Work Commission can consider in the context of a JobKeeper dispute. So the intention at the start of when sending out the invitation for this talk was to be looking at what was going to happen at the end of JobKeeper. We've obviously had an extension of that period of time, and certainly my intention now is at the end of JobKeeper Mark 2, which will occur early next year, is to look at what it actually means now that the JobKeeper scheme has finished, if it finishes at that time, and what it will mean for all employers in terms of their operations and what changes they might need to make in order to get their operation ready for a post-JobKeeper scheme environment. So that's my talk for the purpose of this morning. I'm happy to respond to questions at this juncture.